Is that correct?
That is correct.
Okay. Mr. Chairman, members of the committee, you should have been distributed a memo on Senate Bill 34 from our office. This bill would establish a 5-year sunset on all rules and regulations that are in effect as of July 1st of this year. And then that 5-year time period would also apply to any new rules and regulations that are adopted by the state agencies after July 1st of 2021. The 5-year sunset applies to any new rules and regulations and any regulation that is substantially amended, which means as defined by the bill that the regulation has been broadened or narrowed in scope. The bill would require that by July 15th of each year, the Office of Reviser of Statutes would identify and certify to the Speaker and to the President of the Senate those rules and regulations that are set to expire on the following June 30th, so that the legislature has time to take action on those rules and regulations before they expire. And then finally, the bill provides that rules and regulations are only to be adopted by a state agency if they serve an identifiable public purpose and are no broader in scope than necessary to meet that purpose. The bill would go into effect on July 1st of this year if it was enacted, and I'll be happy to answer any questions the committee may have.
Thank you, Jason. Committee, do we have any questions for Jason on the bill briefing? Senator Foscato.
Thank you, Mr. Vice Chair. Jason, would these rules and regs be subject to overview by the Joint Committee on Rules and Regulations for all state agencies?
The bill does not make any changes to the Joint Committee's review process of those rules and regs, so there is no per se veto authority by the legislature or by the Joint Committee over any rules and regs. This merely establishes a statutory sunset on those rules and regulations. And so if they were allowed to expire, there's nothing preventing the state agency from immediately proposing those regulations, be adopted again upon the next day. And that proposal would go through the normal rule and reg review process for adoption and implementation.
Committee members, do we have any more questions for the reviser? Seeing none. Jason, thank you for your testimony. And we are now ready to open up for proponents. And first up is Senator Hildebrand, which would be myself. Committee members, you have the hard copy of my testimony, so I'm not going to read it or expound on it too much. The only thing I would like to just bring up is in 2019, according to a Mercatus article recently, there are over almost 71,000 restrictions, 3.2 million words in our regulations. That was as of 2019. And according to a Forbes magazine article, the average business will spend around $83,000 to start a new business. It would cost them $83,000 just to keep up with the rules and regulations that they're under, and over $12,000 a year for every year after their startup. So just some things that I wanted to point out, and I will stand for questions after. If committee will just hold questions until after the proponents have all had a chance to speak. So next up is Elizabeth Patton, State Director for Americans for Prosperity.
Again, my name is Elizabeth Patton. I'm the State Director for Americans for Prosperity, Kansas. So as many of you know, we represent thousands of activists across the state, many of whom have sent us plenty of stories and anecdotes across many different industries and examples of red tape being a barrier in many different ways. We at Americans for Prosperity strive to create an economy that works for everyone, where people can succeed and live meaningful lives. And the government has a role in creating a fair and equally applied rules that foster an opportunity-rich environment for all people while protecting against significant public harms. However, we believe that rule should be limited, and it is critical that what we call so-called red tape is removed so that our regulatory process is neither onerous or unnecessary. Over the past few decades, legislatures and all levels of government really have gradually given over broad authority to regulatory agencies to not only carry out the law, but also to create it. So this has created an imbalance of power in an otherwise relatively balanced system. Sorry. And when agencies can create and enforce laws on their own, Americans aren't able to hold their policymakers accountable. But moving on from that, we hope that a bill like this helps to restore those checks and balances, and a review of existing regulations is imperative to making sure that we have struck the correct balance between regulations that that help achieve public safety and ones that are creating a barrier to opportunity. Senator Hildebrand already referenced the Mercatus Center article that talks about the Kansas Administrative Regulations Code containing 3.2 million words. And of those thousands of regulatory barriers, we do believe there is significant room for improvement by removing outdated or ineffective regulations. Researchers and studies have actually also determined that part of a pragmatic roadmap for reducing budget costs can actually be achieved through reducing red tape. And an additional study found that poorer households tend to spend a larger share of their budgets on goods and services that are highly regulated, such as energy, food, drugs, medical supplies, things like that. And so jurisdictions ultimately who have adopted red tape reduction programs in both the United States and in Canada have not experienced diminished protection for public health, safety, or otherwise adverse effects that critics have warned of in the past. Instead, we have seen over and over again as these are implemented that they have experienced resounding economic success. So ultimately, we believe that the successful passage of this legislation can open a path to significantly reducing red tape and compliance costs by allowing both regulators and the regulated community to focus on legitimate rules that protect the public and get rid of extraneous things that are not helpful ultimately for both our economy and our ability to succeed. So, thank you.
Thank you, Elizabeth. And again, committee will hold until after all proponents have had a chance to speak. Alan Cobb, President and CEO of the Kansas Chamber. Thank you, Alan.
Thank you, Mr. Vice Chairman. I'm Alan Cobb, the President and CEO of the Kansas Chamber. Appreciate this opportunity to talk about regulatory reform. It's been part of our overall policy agenda for years. This particular bill and other efforts to reform a regulatory climate at the state level is gaining traction across the country in all kinds of different states, red states, blue states, Midwest, Eastern Coast, West Coast. There's a variety of ways that states can or have implemented a regulatory review process. According to a study by the Mercatus Center, which you referenced, Senator, 10 states have a comprehensive sunset review process, 8 have a regulatory review process, 12 is a selective process of specific agencies, and 6 have a discretionary process where the legislature chooses which agencies and statutes to review. Mercatus classifies Kansas as an alternative approach state where we have an irregular or ad hoc sunset process, along with South Dakota and Vermont. The benefit to Kansas with the legislature being part-time, very busy, this ensures that these regulations are reviewed every 5 years. In the 11 states that Mercatus studied, and all of the data is attached to the testimony, reviewers allowed 21% of the statutes or boards they examined to sunset. 21%, small really number, but I'm sure they were impactful. We've heard some concern from some folks about agencies that they would rather have the state agency being the regulatory body rather than the federal. That's easily adopted where certain regs and or statutes could be exempted in the bill. That's an easy fix, and that has happened in other places. We believe that Senate Bill 34 would establish a system of accountability for state agencies that the legislatures model off of programs in other states. We can learn what worked for them and maybe how to make it work better for Kansas. Happy to answer questions when you get to those. Thank you, Mr. Chairman and members of the committee.
Thank you, Alan. Committee, at this time, I will direct your attention to the written only from Wendy Doyle. Do we have any other individuals that would like to be testify as a proponent on Senate Bill 34? Not seeing any. We will now open up proponents to questions from the committee. Committee, do you have any questions for any of the proponents? Senator Foscato.
Thank you, Mr. Vice Chairman. So my question is for Alan, President, Kansas Chamber, and I'll parlay it into a question that I had for Elizabeth. The cost savings, if you could speak to that, and then in your testimony in the third paragraph of there's a variety, do I sound different without the mask? There's a variety of ways that the state can implement. Just kind of speak to the logistics part of that paragraph, your third paragraph of.
Sure.
Thank you.
And the cost, and I think Elizabeth mentioned this, it's the compliance costs for individuals and businesses who are complying with regulations that maybe don't make any sense anymore economically or from a public safety standpoint. And it's hard to go back and review unless you have a specific method for acquiring the views. So I believe that answers your question. And as far as the process, there are some states, I believe Ohio has done this, where for every new reg, you take 2 out. So it forces the regulatory bodies and agencies to look at regulations that may not be really utilized anymore. The sunset is another one. The REINS Act that you all approved, 3 years ago now, puts an economic development requirement, a cost requirement on new regs. And there may be some things there that we want to tweak. And so there's some states have done 5 years, some have done 7, some have done 10, some stagger, some, again, what I mentioned, and we might want to take a look at this, is exempting certain statutes or the administrative regs from the set review.
And Mr. Chairman, if I may, so in that next paragraph, you say it's a benefit to us because we're in the legislature only a limited time, and you're wanting us to have power to overview when we're not?
Well, you'd still have, and I think the revisor answered this, that for the regulations that are going to be promulgated again, it goes through the same process. But I hear what you're saying. If there's ways to make it smoother or dealing with just the workload of going through 71,000 regs as Mercatus, then we should take a look at it. I don't want to make everything so simple, but if ever the states are doing it, surely we Kansans can figure out how to make it work.
Any further questions for any of the proponents? Seeing none, we will move to neutral testimony. First up for neutrals is Katie Koppel, Deputy Assistant Secretary of State. Welcome, Katie. Thank you.
Thank you, sir. You can probably hear me a little better this way. Vice Chairman Hildebrand, members of the committee, thank you for the opportunity to appear before you this morning. I am Katie Koppel, Deputy Assistant Secretary of State for Communication and Policy. Our office believes Senate Bill 34 is well-intended legislation aimed at eliminating outdated regulations. We think it frankly is a good idea to establish some sort of rules process. However, we do have a few administrative and logistical questions with the bill in its current form, which explains our neutrality. As a bit of background, the Secretary of State is responsible for producing official publications for the state of Kansas. This includes administrative rules and regulations. Our office produces the full set of Kansas administrative rules and regulations. Full disclosure, the last time that full set was produced was 2009. We are on track to produce the first full set this year. In years where the full set is not produced, you receive a supplemental. So with us doing the full set, you will get much smaller supplementals in the following year. As a bit of reference, our publications division as part of the review process for publishing is we receive, review, proof, and publish each rule and regulation. Each rule and regulation submitted to our office is proofed no less than 5 times as part of the review process, and that's from start to finish. Again, for historical context, as of December 31st, 2020, there were 9,325 active rules and regulations in the state of Kansas. And just to help explain the process, at a minimum, it takes about 114 days to review the promulgated rules and regulations once they are submitted for administrative review by the promulgating agency. It can take much longer if the regulations are long, technical, heavily amended, or if if revisions are requested by one of the reviewing agencies, which is the Department of Administration, Division of Budget, and Attorney General's Office. One of the things that came up last year was, what is the administrative review process? So actually on the back of our testimony, we have provided an outline of what the review process is, just in the event it is helpful to you. In our written testimony, we do provide the example of one agency that has 1,766 active regulations. In 2019, this agency submitted, I'm sorry, I lost my place, 9. Last year, they submitted 53. Over the past 5 years, the most this one agency has submitted is 57. So if you, under the bill's current context, this agency would have to file approximately 353 regulations a year, assuming no new regulations are adopted in accordance with federal or state law. Should the committee wish to move forward on this legislation, and again, I want to reiterate, we believe it is a good idea to establish a review process, but we do want to make the following recommendations for clarification in the current bill. The current bill, we believe it could use better clarity on what follows the Senate President and the Speaker of the House of Representatives receiving the certified rules and regulations. In addition, as previously mentioned, many of our rules and regulations are fee-related, or they adopt material by reference on an annual basis, but they don't make substantial changes that either expand or narrow the scope of the regulation. So we would just encourage you to consider clarifying that those that make the slight adjustments maybe be exempt from the sunset process. And then we also would recommend that providing just some additional clarity on what it actually means when the revisor certifies the rules and regulations. One thing we do want to know as part of the process is in 1988, the responsibility for filing regulations was transferred from the reviser of statutes to our office. We are happy to work with them to make sure that should this legislation move forward, that they would have access to those stamped rules and regulations, but we just wanted to provide you that information in full disclosure. Again, we believe this is well-intended legislation to establish a review process. I will highlight, as Mr. Cobb did, a few states that have similar processes. New Jersey does have similar legislation, which was actually implemented in 2001 with a 5-year sunset. I'll take a step back. I am so sorry for your ears. We will note in 2014, the 5-year sunset was extended to 7 years, and they also provide exemptions for instances where a lack of regulation would violate state or federal law. And then they also have an interesting provision where the governor may extend the expiration date, or they can restore an expired regulation within 5 days of it expiring. Another state is West Virginia. They too have a 5-year sunset implementation in 2016 for any regulations filed on or after the implementation of the law. They provide 2 exceptions for education regulations and environmental protection regulations. And then finally, North Carolina has a 10-year review expiration process. That legislation was implemented in 2013. An agency receives 18 months notice of a rule and regulation of theirs that's about to expire. They have also established a review commission, say that 3 times fast. Last year, they were at the halfway point of the review, and 10% of the rules and regulations they had reviewed had been removed and declared unnecessary. 55% remained without change, and 35% were declared needing amended. So again, we're happy to work with you guys however you wish to move forward, but we just, again, wanted to raise some logistical concerns. I thank you for your time and would be happy to stand for questions.
Thank you. And again, committee, we will hold questions until after all the neutrals have had a chance to testify. Next up is Christopher Thomason, Chief Legal Counsel for the Kansas Department of Wildlife, Parks, and Tourism. At least it's tourism for right now.
That's correct, Mr. Vice Chairman. I am Chris Thomason, Chief Counsel for the Kansas Department of Wildlife, Parks, and Tourism, and thank you for allowing me to testify on Senate Bill 34 today. I think this is a good theory, and in practice, I've been doing this for the agency itself for this is my 22nd year. So, long time, a lot of experience in managing regulations. And the department manages about 180 regulations. Some of these are reviewed on an annual basis, like deer season or season-setting regulations, fishing, things like that, turkey season. Some are on a 5-year cycle, like threatened and endangered species regulations. We go through a process that takes about 18 months with public comment and input and scientific review that takes us to that point where we ultimately add or subtract species from that list. And then some regulations go 10 years or more, like deer management units, which are super important for establishing long-term trends and in those populations. And then some regulations may go longer than 10 years, like legal equipment for upland birds, because we set it, and unless there's a problem and the public comes to us and tells us that there's a problem, we don't change it. Everybody knows that we can use shotguns. The problem is the way our statutes are drafted for wildlife and parks, the legislature says you can't do it unless the regulations say you can. So regulations are super important in what we do. And that's what dictates the process by hunting, fishing, camping, parks, boating occurs. Without those regulations, those activities don't get conducted, and there's no corresponding economic impact. And there's a huge economic impact from hunting and fishing for the community and for the state. I think this would add a layer of unnecessary bureaucracy. I think we do have a pretty good process in place by which we promulgate our regulations. And I feel our agency is very responsive to the public. We go out and we have public meetings. This year's an exception with COVID, but we go out and meet with the public. And in fact, I would have to say our participation with our current meeting structure online, we have more participants than we've had, than people can come to a meeting someplace else. I think if the legislature disagrees with the direction of the agency regulation, there's always the purview of the legislature to change the law. And anybody who questions accountability has clearly never come to a Wildlife and Parks Commission meeting where they've had their constituents stand in front of them and tell them what they're doing wrong. And with that, I'd be happy to stand for any questions at any time.
Thank you, Chris. Next up is Tucker Poling, Executive Director of the Kansas State Board of Healing Arts. Thank you, Tucker.
Mr. Vice Chair, members of the committee, my name is Tucker Poling. I'm the Executive Director of the Kansas State Board of Healing Arts. The Kansas State Board of Healing Arts licenses and regulates over 32,000 healthcare professionals in the state of Kansas in 16 different healthcare professions. We are providing neutral testimony here today because echoing what some of the other conferees have stated, you know, we do think it's a good idea to look at this and develop a process by which these things can be more focused, more efficient, and more updated. We do have some questions and concerns about the process. As was referenced, there are many regulations. You know, we as I said, we license and regulate 16 different professions. And in each of our practice acts, there are enabling language in the statute that you as a legislature create, and you often mandate us to create these regulations. It's not a matter of us going out and choosing to do this. And so to go through the process of looking at each one of those is going to be very laborious and resource intensive. And so we would ask you to be sensitive to that and maybe find ways to make that less resource intensive. For us, for example, I was sitting there, during the other conferee's testimony and counting the levels. There are 8 levels of review for every single regulation. And that's not just when we create a new regulation. That's if I want to delete a regulation because I don't think it's necessary, or if I want to cut it down, revise it, same thing, same process. 3 different agencies have to stamp on it, at least 4 different public hearings for every single change. As an example, this is a regulation that I've been trying to change for a couple of years now. It deals with medical schools. And, when I came into the agency, looked at this, it deals with, some details that get into the weeds of the library staff of the school, the diversity of the resources from which the school draws income, how well the catalog is maintained in the library of the school. It's a 6-page regulation. I looked at that and I said, we need to cut that down. It's not in keeping with modern healthcare field. It's just, it is the epitome of red tape. Tried to cut it down to about a half page from 6 pages. And we haven't been able to do that because it's been rejected a couple times. And frankly, probably rightfully so, it's been rejected at the Attorney General level because of the enabling statute. The statute that the legislature created mandates that we create these very specific regs. So this is in my written testimony, and I won't belabor the point, but we would suggest look at those enabling clauses first. I know that can be a daunting task, but look at those. And if the legislature moves forward with a bill like this, make sure that it's integrated with the enabling clauses. In other words, we don't create an inconsistency whereby the standard in this bill is the regulation should be maintained only if it serves an identifiable public purpose and no broader than is necessary to meet the public purpose. If we have a process by which a regulation is deleted under that standard, but we still have the enabling clause that gives a different standard, we just got to turn around and repromulgate it. And we would suggest that's a pretty wasteful process if that's how it would work. So we would ask you to look at that, make sure that those things are considered. Also would ask you to look at the Kansas Judicial Review Act, make sure that there are no inconsistencies created there. The standard in the Kansas Judicial Review Act allows anyone to petition, for example, to have a regulation overruled or deleted by the court system. And that standard sets up a standard if it's unreasonable, then it could be overruled. And I want the legislature to make sure that we're not creating unnecessary litigation by creating a different standard that could compete with that standard. So we would ask that you look to integrate those 2 things. And just to reference something that's in my written testimony, we bring to the legislature's attention. There was a study recently by the National Conference of State Legislators that looked at some efforts to reform regulatory issues, specifically in occupational licensing. And we would ask that you look at some of the experiences that were outlined there. We think that would be helpful. And I will stand for questions at the appropriate time.
Thank you, Tucker. Next up is Alexander Blasey. And she is remote, and she is secretary on behalf of the Kansas State Board of Pharmacy. Alexander, are you there?
I am. Can you hear me?
We can. Thank you.
Excellent. Thank you so much, Mr. Chair and members of the committee. The Board of Pharmacy submits neutral testimony and would certainly echo the comments that have been made by the other neutral conferees this morning. We are, at the Board of Pharmacy, license and regulate both individuals in the practice of pharmacy and also the facilities, your neighborhood pharmacy, and all distributors and manufacturers manufacturers of medications. And in crafting and revising regulations, we do that in conjunction not only under the legislature's authority, but in conjunction with our stakeholders and pharmacy associations, including large federal organizations. And we are always utilizing our regulations to provide additional guidance and details where the Pharmacy Act leaves off in the state of Kansas. So certainly it is never a process that's designed to expand or exceed scope or excessively restrict. And I do take a little bit of issue, as I believe the board members would as well, with this sort of synonymous idea that regulations are red tape. In fact, at the Board of Pharmacy, regulations provide detailed standards, guidance, and protections to ensure that individuals are not harmed in the healthcare setting. While we do have a few administrative regulations, the bulk of our regulations are actually practice-oriented and speak to the actual practice of pharmacy itself. In fact, some of the regulations that the board has recently worked on include those with specific requirements for sterile and non-sterile compounding of medications. Those are the medications that are actually administered and injected into human beings as parenteral products. And so the importance of the safety involved in those processes is just absolutely vital to patient safety. We absolutely agree that there should be a review process. And actually, as we've seen legislation come up in recent years, the board has proactively taken steps to voluntarily begin a systematic review process of all regulations. But much like several of the conferees have indicated, sometimes a review of those regulations indicates that no changes are necessary. And since the administrative rulemaking process is quite substantial in the state of Kansas, where no adjustments are needed, we certainly do not attempt to go through the lengthy process of adopting those regulations if no changes are necessary. I would agree that there does need to be some sort of a timeline, and the board would support a timeline for review of regulations. However, we have some questions, and you can see those outlined in my testimony. This is why we are neutral conferees. As the bill notes, there is a reference to the Office of the Reviser of Statutes, as well as the burden of the legislature to review the regulations systematically, but it actually doesn't speak to the role of the agency. And so in our past experience, the board generally finds that when there is an involvement of the agency, even if it's not referenced in the bill, there does tend to be a burden on the agency, whether it's just an internal review or providing some degree of reporting to the legislature or the Office of the Reviser or whoever that may be. And so the board would just ask for clarification about what the role of the regulatory agency would be in the entirety of this process. And would also perhaps suggest that though we don't take any issue with the 5-year mark, that out of the gate, that 5 years is going to involve a significant amount of regulations. I just counted this morning, the Board of Pharmacy has about 94 regulations. Those don't just fall under the Pharmacy Practice Act. The board is also responsible for regulations under the Prescription Monitoring Program Act, as well as the Controlled Substance Act in the state of Kansas. So, and I'll just say that most of those controlled substance regulations have not needed adjustment in 10 or more years, though the board does stay on top of them and actually hopes to review some later this year. I think that captures the bulk of the items in my testimony. We would just ask for clarification about the items that I've mentioned, and then to reiterate that, of course, we agree that all regulations should serve an identifiable public purpose, but generally we look to the legislature for their indication to us that we should adopt regulations, or the board has the authority to adopt regulations, and so it seems interesting that this is an attempt to place a different standard on the regulatory process that is outlined elsewhere in the Kansas statutes. We also have a question about if the Pharmacy Practice Act specifically states that the board shall adopt regulations, and at some point in the future, the review process should result in a regulation being expired that is under that shall authority. What would be the board's responsibility to then either readopt regulations or adopt new regulations that are mandated by statute? So with that, I will be happy to stand for questions at the appropriate time, Mr. Chair.
Thank you, Alexander. Committee members, I will direct your attention now to written only as neutral from Carol Moreland, Executive Administrator of the Kansas Board of Nursing, and John Goodyear, Staff Attorney, the League of Kansas Municipalities. And now we open up for questions for neutral testimony. And I do have a question, and then I'll follow up with a couple of comments. My first question, Katie Koppel.
Sir, I'll try not to hurt your ears this time.
Thank you. All the committee, well, except for the freshmen that have never served in the legislature before, understands and knows the volume that we receive in the supplements. And I looked, and it's about that tall. So that's every year. Could you give the committee an idea of how tall the full?
The full supplemental right now, and again, it is 11 years old, multiple volumes, I'd say a minimum of 2 feet wide. We are in the process of, like I said, of editing and promulgating a new set for you all. I don't know if this is of interest to you, Mr. Chairman, but we are also, through separate legislation, attempting to modernize how we offer publications to where if you want the hardbound copy, you can still get them, but we also understand consumers, especially given during a pandemic, want digital copies. So yes, you were right. They are, actually, there might be some over there. They are about yay big, and I'd be happy to email you guys a photo of them when I get back to the office, but thank you.
Katie, thank you. And then I had one other question.
Sir.
You had made the comment that one of the states that implemented something similar when they reviewed the rules and regs, like 45% of the rules and regs were either discontinued or they were amended.
That was North Carolina. They have a 10-year expiration or sunset through legislation enacted in 2013. As I mentioned, that an agency will receive 18 months advance notice of a rule or regulation expiring. And then they have also established a regulations review commission or committee. Last year, they were at the halfway point. 10% were removed and declared unnecessary. 55% remained without change, and 35% were declared as needing amended.
Thank you, and it just only confirms our need for review process. And just a couple of comments. I heard a lot of buzzwords thrown out from different conferees, quite substantial to adopt, burden on the agency, labor intensive. Now put yourself in that small business owner's shoes, trying to start a business or keep a business afloat, especially during COVID, of how labor intensive, quite substantial to fulfill their requirements under the rules and regs, and the burden that they have to fulfill that. So any other questions for any neutral? Senator Foscadell.
Thank you, Mr. Vice Chair. I just wanted clarification. The testimony for Scott Swab, Secretary of State, lists testimony for Senate Bill 34 as an opponent, but then, Katie, you're listed as neutral.
Yes, ma'am, that's correct.
Wait,
We are neutral on Senate Bill 34.
so then the testimony is incorrect?
That was an error on my part.
Okay.
I do apologize. We are neutral, we are neutral, we are neutral.
Thank you. Thank you so
ma'am.
much.
Thank you for clarifying, committee. Any more questions for any conferees? Seeing none, we will now move to the opponents. Michelle Meyer, Commission Counsel on Kansas Commission Peace Officer Standards and Training.
Thank you, Vice Chair, and thank you for the opportunity to be here today. Can you hear me okay? Okay, great. I'm legal counsel with the Commission on Peace Officer Standards and Training, and we regulate all law enforcement officers in Kansas. So the reason that we're an opponent today is because we are just requesting an exemption for C-Post from this legislation, and I will go through the reasons of why I think that's important. The first reason being, law enforcement is different than any of the other the testimony that has been brought up as proponent testimony. Every officer in Kansas has to be employed by a law enforcement agency. And so we're not talking about commerce and business and regulations and an onus on business the same way that we are with other regulations. It's an important safety function for us to be able to regulate law enforcement officers. And again, we just are a little bit different category than some of the other agencies. We do support, we understand that this type of legislation has been introduced in many other states and that a lot of states have acted on this. And so we support, obviously, whatever the legislature feels is necessary so that we are, as an agency, are doing what you believe should be done by our agency. And we would like to work with you in that area. The current process does have a lot of legislative oversight. I know a couple of the other conferees have mentioned that, but I just, for visual purposes, wanted to show you, this is what we have to do every time that we want to enact a regulation, and if we want to repeal it. So it's an onerous process, and it does require oversight from several agencies, including a legislative committee and a number of hearings. And as you've heard already, it's a time-consuming process. Our concern, if this were to be, if CPOS were to be subject to this legislation, is some of it is a timing issue. The way that the bill reads at this point, the regulations would be introduced to the legislature basically on the year that they're going to expire. If the legislature chooses not to renew those regulations, we as an agency wouldn't have time to get new regulations either implemented or get to the legislative session to get changes in our statute. And what that means for cops is that where we can take certification action on an officer that uses unreasonable use of force. That's a hot topic that nobody wants that to happen. And that is in our regulation. And so if those regulations were allowed to expire or be repealed, we'd no longer be able to do that. We'd also no longer be able to take action on unprofessional conduct from officers, like using their position to get something of gain, or taking action or not taking action because of a relationship, a personal relationship of the officer with someone else, and misdemeanor theft on the officer, and 57 other misdemeanors. Like many of the other conferees have suggested, it is in our statute that we define what unprofessional conduct is in our regulations. So that's what we've done. And so, as I mentioned, if this were to go into effect and that were to change, we would have to have a legislative change. And it's hard. I mean, I know that some of you have difficulties getting your bills passed that you want passed. So do we. We've had instances where we just wanted a definition change that would make sure that our definition for misdemeanor crime and domestic violence was the same as what it is federally, and it took us 2 years to get that done. So we are concerned about what this impact could have on Kansas CPOS. And the other concern I have is with the standard that's listed in the legislation about what the regulations have to be. Again, everyone here knows that there's a lot of discussion about police reform right now. There's some good discussion. I know Senator Faust-Godot has a Senate Bill 9 that you've introduced that has some, exciting ramifications that might be in place. Some of those types of reform ideas and the reform ideas that were introduced by the Commission on Racial Equity and Justice may be best enacted through administrative regulations, but they're not necessarily going to meet that standard that's right here. So we certainly want to work with the legislature to ensure that we're doing the appropriate regulation, but because of how different we are from other entities, we would ask for an exception for this. And then the only other thing I wanted to point out was just that I do have a U.S. Department of Labor, U.S. Bureau of Labor Statistics article from May of 2015, and it indicated that since the 1970s, about 36 states passed sunset laws regarding licensing on occupational boards, and then subsequently about half of those states later repealed or suspended those laws, and then many others limit the frequency of the audits or change that time frame. So I would join in the other conferees that indicated perhaps we could do this more a la carte type system, or in a way that we can look specifically at our statute, and we're happy to work with you in any way that we can, and I'll stand for questions when appropriate. Thank you.
Thank you. Next up is Aaron Poplicka, Vice President of Legal and Government Affairs with the Kansas Livestock Association. Welcome, Aaron.
Thank you, Mr. Vice Chairman, members of the committee. A pleasure to be here. My name is Aaron Popelka, Vice President, Legal and Government Affairs for Kansas Livestock Association. So I want to start today. Those of you who probably know our organization, we're pretty free market, low government regulatory burden is kind of our policy. And the reason we're here today is more procedural based, not substance. We think the substance of the bill is great. We need to find ways to get burdensome regulations off the book. But I want to highlight some of the process issues with the bill. And again, the reason I'm here as an opponent, we tend to think if there's issues, then we ought to show up and say what the issues are and not say that we like the bill. But if the issues are resolved, we could probably get on a different page here. I think one of the issues I want to highlight is, and I think Alan Cobb touched on this earlier, is that there are some regulations that actually incorporate federal regulations into our system because our agencies have delegated federal authority. The one impacting livestock producers most directly would be Clean Water Act. The permits we have to operate feed yards, that is a federal law that Kansas has delegated authority for. So we would not want to see those types of regulations sunset, because that could put us in a situation where instead of a state agency that while we may have issues with from time to time, we can generally work with compared to the EPA, because if those regs sunset, EPA immediately steps in and begins regulating our industry, something we do not want to see. The other issue is some statutes, like our animal health statutes, generally say that, like for instance, Department of Ag should prevent infectious diseases in livestock from entering the state, and then they actually don't go through and list any of the diseases. Part of that's flexibility to adjust to diseases. Well, if those sunset, we're now in a situation where, for instance, Kansas has tuberculosis, bovine tuberculosis-free status. Other states do not, and so all of a sudden our regulations that prevent cattle from those states that are affected with bovine tuberculosis can come in without any health papers. Those are to highlight some of the regs that are important that perhaps, that the legislature has stated need to be there. Maybe there's a way to work that so that those can be expeditiously kept on the books. The other is the potential. I think one of the issues here is we're sunsetting everything on the books currently all at one time. And there's some concern this could create a backlog for those regulations that actually are necessary to function, like environmental permits, like water permits. And the reason there's a backlog is, and I think the agencies alluded to it, right now there's a tremendous time lag for regulations, and that includes good regulations. For instance, right now we're working with Department of Health and Environment on a reg that would reduce regulatory burden and cut costs. That is now languished for over a year. The primary backup would be the Office of Budget. Alan Cobb mentioned the RAINS Act, state version of the RAINS Act requires an economic analysis, and that's great for regulations that cause a lot of costs on businesses and government. But for ones that actually cut costs, those should be moved to the front of the line and not be put behind these regulations that are taking a long time to analyze because of substantial costs. So that's one change I think that needs to be made if we're going to have these sort of sunsets, is if there are regs that don't cost money, aren't a burden, we ought to facilitate those through that economic analysis process. The other thing I think to think about is currently if an agency wants to change a reg, they have to give notice and comment that they're going to repeal it, and then notice and comment that they're going to replace it with something. And that gives the public, associations like mine, time to analyze it, get involved, and if necessary, push back because it's a burden. Again, getting to all of them sunsetting at once, this could really create an opportunity for potential shenanigans if, for instance, you have an administration that perhaps you may not agree with. Think back over history of all the administrations that have held the governor's seat in this state. I'm guessing that some of you may not agree with all of them, And if we have all these regulations, some that maybe from administration you agree with, exiting, you now give an administration you might not agree with the opportunity to put in place a regulation that you really don't want. Because you've essentially short-circuited that rulemaking process. That reg is now off the books, and they can immediately start the notice and comment with many others. I don't like to come up here and kind of go through a list of challenges without solutions, because we do want to see the regulatory burden decreased in this state. I think one thing that the legislature can look at is, you know, Congress has the Congressional Review Act that says any new regulation we can, within a certain time frame, reject. The challenge in Kansas is there's an appellate court case that says the Constitution in Kansas doesn't allow the legislature to do that. So to allow that, you actually have to do a constitutional amendment, and it's my understanding Attorney General Schmidt may be working on one of those, and we would support that effort if it materializes this session. The other is, I mentioned on the economic review analysis, if a regulation actually shows to have no cost or indeed decrease costs, then those should be moved to the front of that list so that those that actually help industry reduce costs are the ones that have kind of the priority. The other is, again, getting back to those instances where something's required by federal law and we've adopted by reference some federal regs so that the state agency can enforce those federal laws. Those sorts of things should probably be exempt from this process because, again, if we don't have those regs, the default is EPA comes in and not the state agencies. So I think that's maybe an easy fix in this bill. And finally, as I mentioned, you know, if this does move forward, perhaps staggering the regs so that they don't all fall at once and create, again, opportunities for agencies to potentially put something in place that might be more burdensome than what's there now. So with that, Mr. Chairman, thank you, and happy to stand for questions at the appropriate time.
Thank you, Aaron. Next up, we have Larry Carnes, Executive Director of the Kansas State Board of Technical Professions. Thank you, Larry.
Good morning. I'm a little shorter. I need this down a little further. I am Larry Carnes. I'm the Executive Director of the Kansas State Board of Technical Professions. We license engineers, architects, geologists to practice in Kansas. My board's made up of professional people. They use their learned knowledge to adopt regulations that are needed to regulate technical professions. I have two concerns with this bill. That's why I've listed as an opponent. I think everyone agrees that outdated regulations should be reviewed and suspended and revoked. I'm worried about the procedure and the standards that are placed in this bill. This bill is only 1 page long. It has 2 major points. But I don't think it really seriously addresses how we're going to accomplish these instances. It says after 5 years, all regulations are going to be revoked, except in line 12, it says, unless the legislature adopts legislation to renew such regulation. What standard is the legislature going to use to decide whether they're going to renew or let it expire? The bill in subsection D, 3 lines, says a rule or regulation may be adopted or maintained by a state agency only if it serves an identifiable public purpose and may be no broader than necessary to meet that public purpose. Is that the standard the legislature is going to have to apply to the thousands of regulations they have to look at? Look at each one and determine whether it meets an identifiable public purpose and that it's no broader than necessary to accomplish that purpose? That to me is an overwhelming burden for the legislature to accomplish. It's a good soundbite, but I just don't see how in practicality it can be applied. I'm concerned about this business of saying no broader than necessary. It sounds good, but how do you decide what's no broader than necessary? You know, in my business, we have people with differing economic interests. You have consumers, you have business owners, you have practitioners. One person may think a regulation is just right. Another one might think it's too hard or too soft, taking a Goldilocks approach to determining whether or not the regulation should be approved or not approved or modified or not modified. How do you decide what's just broad enough? It's a balance. It's a balancing test. And I can't imagine the legislature wants to go through each and every regulation and to make that determination. That's why they've delegated that authority to boards, particularly boards like mine that are made up of professionals who have expertise and learned knowledge in these areas. Just as an example, we determine how many years of practice, supervised experience you have to have before you become licensed as an engineer or an architect, whatever. I'm sure different minds could differ on how many years of experience you have to have before you get licensed. Some would think very few years, some would think very many years. Someone's got to make that determination. And if our regulation requiring that as years of practice is suspended after 5 years, the legislature has to make a determination whether or not to renew it or not. Is the legislature now going to take it upon themselves to decide that standard? I think that the idea is admirable. I think regulations should be reviewed on a periodic basis, and burdensome regulations obviously shouldn't stand. But I think this one-page bill doesn't really give you a roadmap of how you're going to accomplish that. I'd be happy to stand for questions.
Thank you, Larry. Committee, I'd like to turn your attention to written-only opponents. John Donnelly, Kansas Farm Bureau, and Terry Humphrey, Executive Director of AIA of Kansas. Do we have anybody else that would like to speak as an opponent on Senate Bill 34? Okay. Committee, do we have questions for Senator Longbine?
Thank you, Mr. Chairman. I don't have a question for the opponents, but if the decision is made to go forward on this, I'm wondering if we could request that the budget office get us a better fiscal note. I noticed in reading through the fiscal note that there are, this bill would cost about 70 FTEs and about $4.2 million, but they only surveyed 17 agencies, and we have many more than that. And so if we could get maybe a little closer on the fiscal note, probably be helpful.
Sure. Fiscal notes are always interesting to read. You can always tell when a body giving you the fiscal note is for or against a bill. So, but yeah, I think that's a good request. So thank you. Any other questions for any of the opponents? Seeing none, we will close the hearing on Senate Bill 34. Committee, we had Senate Bill 35 on the agenda. It doesn't appear that we're going to have time to have that hearing, so we will postpone that, I believe, Thursday. We will do that on Thursday. So if there is nothing more to come before the committee, we are adjourned. Whoops. Just a quick reminder that ABC will be giving a virtual hearing or update on their agency. So, committee? Senator Foscato.
Thank you, Mr. Chairman. I thought you were putting a prank on me. I thought that guy Larry was Dr. Fauci. Didn't he look like him?
Thank you, Senator Foscato, for ending this meeting on that. So, committee, we are adjourned. Thank you.